and for the second respondent. David Kahoro.
Filed an application for which I have applied for your keys on this matter.
Mr. Itumbi, sit down. When a matter is fit for ruling or judgment, what comes first? Let me read my ruling, then you can make your
Your Honor, my presentation was that once your ruling, in the event that your ruling finds against my application.
Are you preempting the ruling?
No, I am not preempting the ruling. I'm only saying that the court will be found sufficient. That's what you get on record.
No. There are procedures in courts of law. When a matter is fixed for plea, it comes for plea. When it comes for ruling, it comes for ruling. When it's for judgment, it's for judgment. The procedure demands that the one step after the other. Unless you have different law, guide the court on that.
No, Your Honor. I just wanted to put a record and put an application for you. That application has an impact on the ruling you're about to make. It is only therefore fair, Your Honor, that you grant.
My ruling is ready. Listen to the ruling and then make your application. That is the procedure I have practiced for the last 25 years. Mr. Itumbi, sit down. Please. Mr. Itumbi, sit down. Please.
Much obliged.
Yes. This is the ruling that is for today. Yeah, forget about that. Happens. Now, the applicant Dennis Itumbi, by way of a certificate of urgency, accompanied by a notice of motion and an affidavit sworn by himself, all dated 18th of November 2020, moved the court for the following orders. That this application be certified as urgent and service be dispensed with. That the applicant acting in person be granted permission to conduct the intended present prosecution. Now this honorable court is pleased to issue summons compelling the attendance of the first respondent accused person named herein to appear before this court, this honorable court, on a date specified in those summons to enable the honorable court to deal with the charges. That this honorable court be pleased to make any other orders it deems fit. Anti-corruption courts draw the authority from section 4 of ASECA, which also provides guidelines for trial. I have informed myself on all the provisions of the said act and have satisfied myself that I have the necessary jurisdiction to hear and determine this application. The application was filed on 23rd November 2020 was based on 22 grounds. As I was required to do, I set the ex parte application for hearing on the 24th day of November 2020. The applicant was accorded a chance and was heard on whether his application had met the necessary threshold of enabling the court to issue summons compelling the first respondent to attend court on a given day. While arguing his application, the applicant described himself as an experienced investigative journalist who has worked with local media houses and as an international correspondent who has also published his own county newspapers. In his affidavit, the applicant gave a chronology of events culminating to his application for court. He also relied on the cases of floriculture and 4 others versus AG Nairobi, miscellaneous application number 114 of 1997, R versus Chief Magistrate and 4 others, and Moses Abumba, 2016 PKNR, and submitted that there was a clear procedure. Further that, he informed the investigators via a letter dated 8 October 2020, marked B146 and B147 to the interested party, and a response to which he replied by B148. That the second respondent by B146 said they will update the applicant in due course. The applicant informed the court that he obtained the document particularized in his affidavit from public officers pursuant to Article 35 of the Constitution on access to information. That he did not make any request for the information but used Article 34 of the Constitution on the freedom of the media. While being referred to Section 80 and 81 of the Evidence Act Part 80, he informed the court that this being a special prosecution, being a layman, and having been frustrated by investigative agencies like the interested party and the second respondent, he did not pay for the document. He concluded by seeking for an order to define witness statements. The court took notice of the prerogative of the second respondent in court and made necessary directions. His affidavit had a total of 82 paragraphs and 50 annexures, marked from B1 to B150. He viewed the proposed 4 charges against the first respondent, 3 of which were brought under the Corruption and Economic Crimes Act as 2003, otherwise called as SECA, and 1 under the Penal Code Cap 65 Laws of Kenya. In determining this application, the court informed itself of the previous decisions by superior courts by which it's bound. They are Isaac Alot Polo Aluchier versus Kalonzo Musyoka and 218 others, 2013 PKNR, Floriculture International Limited and others versus R, ICOS miscellaneous application number 114, cited with approval, that is the Floriculture International Limited and others versus R, cited with approval in Otieno Clifford Richard versus Republic High Court Nairobi Miscellaneous Civil Suit number 720 of 2015, R versus CM's Court with the money and UPP and 3 others, 3 other interested parties, that was a JR Miscellaneous Civil Application number 622 of 2018. Having done that and having been guided by the said decisions and the law, the first issue for determination is whether the applicant within 30 days of instituting these proceedings notified the second respondent. At paragraph 70 of his affidavit, the applicant informed the court that he wrote a letter dated 5 October 2020 to the second respondent and the interested party inquiring about the investigations and eventual prosecution. He annexed a copy of the said letter marked B146. That by a letter marked B147, the interested party gave him an unsatisfactory answer, and the applicant went ahead to issue a notice dated 14 October 2020, that is B48, informing them that he was not satisfied and would pursue legal legal remedies available to him. He did not indicate the legal remedies. I perused the documents mentioned in the above paragraph are noted as follows. In D146 and D148, the applicant wrote the same letters as the Hustler Nation spokesman. I find that both documents fall within 30 days of filing these proceedings. The next point for determination is whether the second respondent, without reasonable cause, declined to institute the resumed proceedings. In paragraph 68 of the affidavit, the applicant indicated that sometime in 2018, the second respondent, upon receipt of the investigations file from the interested party, returned the file 3 times, recommending that the interested party must include officers from the Director of Criminal Investigation Land Fraud Department into the investigation in order to have a watertight case against the culprits to be charged. At paragraph 74 of the same affidavit, the applicant informed the court that by virtue of the constitutional mandate of the interested parties, despite at paragraph 73 that the second respondent did not respond to issues raised in the letter, also informed the court that the interested party had no reasonable cause why it had not concluded the investigations to the loss of public funds. There is nothing in the affidavit demonstrating that the second respondent actually refused to prosecute. Returning a file for further investigations does not amount to a denial to prosecute. The next issue is whether evidence by way of an affidavit in this application meets both the constitutional and legal threshold in order to enable the court grant permission to initiate a private prosecution. The affidavit introduced both public and private documents. None of the paragraphs indicated the sources of information. When a litigant relies on evidence by way of an affidavit, that litigant must disclose the sources of information. While having his application, the applicant informed the court that he obtained the said evidence pursuant to Article 34 and 35 of the Constitution. For purposes of these proceedings, the relevant article is Article 35, which states, as quoted here under Article 35(1), every citizen has the right of access to A, information held by the state, B, information held by any other person, and required for the exercise of any right or fundamental freedom. Access to information is a right bestowed upon each and every citizen. This right, just like any other right, must be exercised by the citizen seeking the same. The applicant did not demonstrate how he exercised his right under Article 35 that led to laying his hands on the information he seeks to rely on. Did he send a request? Or did he just walk into the offices and obtain the documentary evidence? If so, from whom? The applicant did not explain how he accessed the information. The documents in his affidavit have the names of the makers. However, his affidavit does not contain any information as to whether he had the permission of the makers to use the said documents. Such information, in order to be relied on by the court in a criminal process, ought to be accompanied by witness statements by the makers or such other person who had such custody as and when the applicant obtained them. By not demonstrating how he obtained the evidence he intends to rely on, such evidence is amenable and susceptible to Article 54 of the Constitution, which states as follows. Evidence obtained in a manner that violates any right or fundamental freedom in the Bill of Rights shall be excluded if the admission of such evidence would render the trial unfair trial, or would otherwise be detrimental to the administration of justice. he ought to have explained how he obtained each and every piece of evidence in his affidavit. As indicated above, the applicant introduced both public and private documents. Among the documents were letters written by public bodies, among others, the Ministry of Education, the National Treasury, the Commission of Lands, Director of Survey, etc. The legal threshold of such evidence is found between Section 79 to 81 of the Evidence Act 80 laws of Kenya, which inter alia states as follows. The following documents are public documents. A. Documents forming the acts of the state. A2. Of documents forming the act of the state of official bodies. And B. Public records kept in Kenya of private documents. Section 81. Every public officer having the custody of a public document which any person has a right to inspect shall give the person on demand a copy of it on payment of legal fees therefore, together with a certificate written at the foot of such copy that it's a true copy of such document or part thereof, as the case may be. And such certificate shall be dated and subscribed by such officer with his name and title, and shall be sealed whenever such officer is authorized to make a seal. And such copies so certified shall be called certified copies. Section 81. Certified copies of public documents may be introduced in proof of the contents of the documents or parts of the documents of which they purport to be copies. The applicant relied on his exhibits D1 to D43 that fall in the category of both Section 79(1), A2, and B above, while the others were generated by the applicant. Guided by the above provisions of the law, the court noted as follows. There was no demonstration of any demand to the custodians of the public documents. There was no proof of payment of the required legal fees. There was no certificates written at the foot of the said documents demonstrating that they were true copies of the originals. Neither were they signed or dated and subscribed by such officer with his name and title. Hence, 81 comes into play. The said documents as they are not certified as required and hence cannot be produced in court as proof of the contents of the documents that they purport to be. The understanding of the court is that besides the affidavit being defective, the exhibits attached thereto do not meet the admissibility test as provided in the Evidence Act 80 laws of Kenya. D35, D37, D39, and D42 are letters from the Ministry of Education, where the first respondent was the Cabinet Secretary. The court perused and noted their contents. None of the said letters was authored by the first respondent. In criminal proceedings, the doctrine of vicarious liability does not apply. According to the Black's Law Dictionary, 10th edition, vicarious liability is liability that a supervisory party, such as an employer, bears the actionable conduct of a subordinate, based on the relationship between the two parties. This applies only in torts and not in criminal proceedings. In criminal process, the party accused of either committing or omitting to do the act complained of is the one liable. At paragraph 7 of the affidavit, the applicant quoted paragraph 176 of the judgment finding of the High Court in the case of National Commission versus Afrison Export Import Limited and others, 2019 EKLR. That paragraph reads as follows, and I quote: had the applicant conducted an inquiry in accordance with the law, that means the applicant in the case I have quoted, had the applicant conducted an inquiry in accordance with the law, it would have been discovered that the land which was to be acquired for the two schools had already been surrendered and set aside for public purposes. We therefore find that the compulsory acquisition of the land on which the two schools sit did not meet the threshold of public purpose and should not have been undertaken in the first place. One cannot purport to compulsorily acquire what is already public land. It is the applicant which started off the acquisition process on a complaint based on historical injustice, which was then turned into a compulsory acquisition. Despite the sixth accused party insisting on due diligence being followed, the applicant did not do this. Instead, the applicant misled the Ministry of Education into undertaking a compulsory acquisition exercise that was totally unnecessary and led to loss of public funds. End of quote. The applicant, instead of quoting that paragraph in the manner in which it was pronounced by the High Court, he decided to perjure himself on oath by stating only the undersigned part of the above paragraph. This court finds that further to what the court observed above, by the applicant trying to mislead the court, the case alluded to absolve the officials of the Ministry of Education. And the Holy Bible guides that, be honest and God will reward you. Lastly, having said as above, and due to the other findings herein above, the court finds that the applicant's application dated 18th November 2020 failed to meet both the constitutional and legal thresholds that would give this court the necessary authority to grant permission to the applicant in order to enable him in private prosecution proceedings against the first respondent. The upshot of the matter is that the said application stands dismissed.
Honorable Your Honor, I would wish to request for subsequent copies of the proceedings and may the record reflect that I filed an application before you.
Similarly, although you are not parties to the expert hearing,
That's just a moment. Let that.
similarly, although you are not part of the expert hearing, you'll be asking for a copy of the ruling for our records. A similar application is made by the interested party.
Yes, Mr. Itumbi, your application is allowed subject to payment of legal